The history of this law goes all the way back to the early 2000s after the Enron and other accounting scandals. U.S. Senator Paul Sarbanes and U.S. Representative Michael G. Oxley sponsored a bill in 2002 called Sarbanes-Oxley, or SOX. The Sarbanes-Oxley Act of 2002 imposes criminal liability on anyone who corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so, with the intent to impair the object's integrity or availability for use in an official proceeding. The next subsection extends that prohibition to anyone who otherwise obstructs, influences, or impedes an official proceeding or attempts to do so. There's a bit of a problem already with the Sarbanes-Oxley Act. Subsection C1 criminalizes the destruction of records, but it's part of a section of the law regarding tampering with witnesses, not records. They could have placed the language in Section 1510, obstruction of criminal investigations, or Section 1519, destruction, alteration, falsification of records in federal investigations and bankruptcy. Instead, they put this document tampering language in a section of the law dealing with witness intimidation. Petitioner Joseph Fischer was charged with violating 1512c2 for the conduct on January 6, 2021. On that day, Congress convened a joint session to certify the votes in the 2020 presidential election. This breach of the Capitol delayed the certification of the vote. The criminal complaint alleges that Fischer was among those who invaded the building. Fischer was charged with various crimes for his actions on January 6, including obstructing an official proceeding in violation of 1512c2. The breach of the Capitol did not delay the certification of the vote because, as I've already pointed out, Congress doesn't certify the vote. The breach did delay the counting of the votes, but while Mr. Fischer's actions may have extended the delay, it did not cause it. As the complaint stated, Mr. Fischer did not enter the Capitol until an hour after they had recessed. However, that is not why Mr. Fischer challenged this count in his indictment. He moved to dismiss that charge, arguing that the provision criminalizes only attempts to impair the availability or integrity of evidence. The district court granted his motion in relevant part. A divided panel of the D.C. Circuit reversed and remanded for further proceedings. Which brings us to the critical word, otherwise. Section 1512c1 describes particular types of criminal conduct in specific terms. The purpose of C2 is, as the parties agree, to cover some set of matters not specifically contemplated by C1. Perhaps Congress sought to criminalize all obstructive acts in 1512c, and having named a few examples in C1, devised C2 to prohibit the rest. But C2 could have a narrower scope if Congress designed it to fill inadvertent gaps in the focus language of C1. Did Congress mean to criminalize all obstructive acts, or was subsection C2 only meant to fill in any gaps left in C1? How does the court perceive the intent of Congress? One way to discern the reach of an otherwise clause is to look for guidance from whatever examples come before it. Two general principles are relevant. First, the canon of noscitur et sauce teaches that a word is given more precise content by the neighboring words with which it is associated. And under the related canon of e jurisdictum generis, a general or collective term at the end of a list of specific items is typically controlled and defined by reference to those specific items that precede it. These approaches to statutory interpretation track the common sense intuition that Congress would not ordinarily introduce a general term that renders meaningless the specific text that accompanies it. Have you ever wondered why attorneys and judges like to use fancy Latin sayings rather than simple English? If you look at the definitions of both noscitur et sauce and e jurisdictum genere, they mean pretty much the same thing. You define an ambiguous word by its context. Under these principles, the otherwise provision of 1512c2 is limited by the list of specific criminal violations that precede it in C1. If, as the government asserts, C2 covers all forms of obstructive conduct beyond 1512c1, focused on evidence of impairment, Congress would have had little reason to provide any specific examples at all. And the sweep of subsection C2 would swallow C1, leaving that narrower provision with no work to do. I've seen this argument before with the General Welfare Clause. If the framers of the Constitution meant the General Welfare Clause authorized pretty much anything Congress thought was good, why follow it with 17 specific powers? Back to the court opinion. It makes sense to read C2 as limited by C1 in light of the history of the provision. The Enron accounting scandal exposed a loophole in 1512. At that time, the statute imposed liability on anyone who, among other things, corruptly persuaded another person to shred documents, but it curiously failed to impose liability on a person who destroyed records himself. The parties agree that Congress enacted 1512C as part of the broader Sarbanes-Oxley Act to plug this loophole. It'd be peculiar to conclude that in closing the Enron gap, Congress created a catch-all provision that reaches beyond the scenarios that promoted the legislation. By reading C2 in light of C1, the court affords proper respect to the prerogatives of Congress in carrying out the quintessentially legislative act of defining crimes and setting the penalties for them. As Chief Justice Roberts writes in the opinion, C2 of 1512 must be read in the light of C1, leading to the following conclusion. To provide a violation of Section 1512C2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or, as we earlier explained, other things used in the proceedings or attempted to do so. The judgment of the D.C. Circuit is therefore vacated, and the case is remanded for further proceedings consistent with this opinion. On remand, the D.C. Circuit may assess the sufficiency of Count 3 of Fisher's indictment in light of our interpretation of Section 1512C2. It is so ordered. So Mr. Fisher's case goes back to the Circuit Court to be heard again. This time, though, the Circuit Court is to follow the opinion of the Supreme Court and read subsection C2 in the light of subsection C1.